Welcome to the Domain Name Law Show. We're live streaming on YouTube as well. Thanks for joining us. My name is Todd Ryan. I have two co-hosts, Jeffrey Neuman and David Michaels. Let me say hi to David first. Hey, David, how's everything going? Okay, that's plenty. Hey, Jeffrey, are you at the airport? I know you're traveling. What's happening? Well, thanks for being here. And what David and I were talking about, or David, Jeff, and I, we live stream on YouTube now. So if you want to check that out, you can go to, I'll have a direct link, but it's youtube.com/TRABC. But okay, so of course we're here. The replays are going to be here on X. We got a live stream on YouTube, and we'll, of course, have a YouTube replay available as soon as the show's over, too. But now David was saying as he was listening back, it sounded like Jeff was loud, I was average, and David's audio was a little bit low. But we'll see how that goes today. Hope everything's fine here. Yeah, I'm like, and every week we sit here, Jeff and I'm always like, I know Dave's going to show up, but wait, it's always 12:01, 3:01 for him. All right, we have a big show today. If you want to follow along, we got a lot to cover. Try to get through it, and then a question and answer session um, once we get through our UDRP reviews, because sometimes people have domain name legal questions, and love to have some people join us on stage. Okay, so if you check out the outline this week for show number 216, you can see it at dnlshow.com/outline. And today we were going to start with the topic that we touched on last week, but because the lawyers, David and Jeff, didn't get to really look at it, was a lawsuit from last year, but um, it's still very interesting. It was about alo.com, the domain name. So to refresh your memory real fast, Alo Yoga filed a UDRP against this respondent who's from South Korea for the beautiful domain name alo.com. Well, in that case, the respondent's lawyers really made a bad move because, I'm sorry, the complainant's lawyers made a bad move because this really wasn't a case made or that was going to be successful as a UDRP complaint. And not only was it not successful, the panelists agreed and ruled reverse domain name hijacking, meaning you abused the system by even filing this complaint because you should have known you had no chance of winning. And the primary reason was this domain name alo.com was registered well prior to Alo Yoga's trademark. So they lost the UDRP, yet they still thought they had rights to the name because they felt like the owner of the domain was infringing on their trademark. Well, they hired a new set of lawyers, basically David Westlow over at Wiley Ryan, and filed a lawsuit against the domain in rem, meaning the domain as property, and the court ruled in their favor. Primarily, I guess the main reason was because there was no response to the domain name. Now we're going to talk about whether we think the case was decided properly. I guess there's no way if they don't respond in a court case, it's decided properly because it's default. But we're going to dive into, did they, was this a really a fair case to file? When I say, of course, it was fair to file, but still seems like the attorneys, David Westlow at Wiley Ryan, I don't think really they had rights to this name. But first, let me start with you, David. I know you've done some work, looking at this. Touch base on, the past UDRP complaint, this lawsuit, and how you feel about it. Yeah, sure. But Jeff, what do you have to say about this? And let David do some work, and then I'll give my comments on it. Because, like I said, pretty simple. They lost the UDRP. It was a reverse domain name hijacking. They went ahead and filed a trademark infringement case by filing an ACPA case, and they won. Go ahead. Yeah. So, good. David, I'm going to play the other side. Hold on, Jeff. Okay? So one, the I guess that you're right, but lawyers disagreed. Many lawyers say, and I mean, I'm not talking like Trump, like many. I actually have talked to many about this, and they're saying, yeah, no obligation to discuss that, but like you said, they're omitting it. Really, is not. They're not filing this complaint, say in good faith or with all the facts pertaining to any communication or issues. I was going to say it, since it's not litigation amongst the parties. Like I said, lawyers are saying, well, maybe they don't need to do it. They don't need to say it's an RDNH. But so the point was, it doesn't matter if there was bad faith registration in the trademark infringement case. All it matters is, are they infringing? And they're saying, because of these PPC links, and believe it, that's what they were. These were links going to Alo Yoga. So they certainly were links on the website going to the complainant, going to the plaintiff in this case. So the plaintiff made their case that, that standard case, we haven't given them rights to put up links to our site or to resellers of our product. And we haven't given those resellers authorization because some of the links were to resellers of Alo Yoga products. And they said, this domain owner, this defendant in the case, has kept their privacy, has done it on purpose, to trying to prevent us to find out who this is, and that's why we're filing in rem. And basically, they just made really a standard case. But I will say this for the attorneys, for the complainant, they knew the fucking UDRP was not the right forum for this case in the first place. That's why it was some lawyers that filed on behalf of Alo Yoga shouldn't have filed it. They weren't going to win because there was no bad faith registration. But another lawyer, like I said, they come in, Wiley Ryan, and Wiley Ryan says, well, we don't care about that. Is there trademark infringement going on or not? Are they infringing on your mark? And let's look. So they take a look, and they're looking, well, they sure have in the last several years, and that is they're keeping you from using it. They're going through all the natural things that a trademark infringement case goes through. Is not only they're infringing on your rights, preventing you from using it, they're taking advantage of your mark. You haven't authorized the whole thing, and they go through and they should have evidence. They've submitted evidence showing, here's this link, here's that link. They're using their mark, and when there's no answer, I don't know, what else you could expect the judge to do, to say, hey, other than, you sure there wasn't anything? Even if they did, admit to the UDRP, it was not going to hold any weight, and it was just the wrong forum for this thing anyway. You don't take a trademark infringement case to an administrative hearing for a domain dispute. But so I'm agreeing with Jeff that, yeah, it was all crazy last week until I realized, well, I think if they would have defended themselves, they would have had a good defense, and we would have went back to the basic stuff of, well, where did these pay-per-click links come from, and then other usage that they had prior to that to help show that if there was infringement. I don't know, because infringement doesn't matter if it's intentional or not. So because of these links, it's like they lost. But Jeff and David both. So Jeff, first, when it comes to having PPC links in a UDRP, we know that can be bad, but they hold the same weight in a trademark infringement case. Meaning, do you have any defense when you have these PPC links that are linking to the plaintiff's site or product? David, what other comments do you have on this? Well, we're going to talk briefly about the Pru case. I hope you're ready. But basically, what domain investors need to know from this is, okay, purple.com goes to Purple Mattress. Okay. But let's say you owned purple.com, you picked it up a few years ago. If you um, monetize it with PPC links, and there's some links that go to Purple Mattress, it doesn't matter if you own that domain prior to their trademark registration. If you start using it commercially and you have PPC links going to, and that in purple doesn't mean mattress, so that is fanciful. I mean, it is unique. So if you owned purple, like that prior registrant who sold it to purple.com or who sold it to the mattress company, hope they made big dough. But that previous owner, if they had it free and clear and used it and were selling whatever purple crayons, or they did whatever they want, but then they eventually started making money off of it, even the slightest amount with PPC links, and they're pointing it to Purple Mattress. It's after the fact, meaning that sure they had the domain prior to the trademark, but if they start infringing on the mark, and the courts are just, I see there's a few other cases where the courts, as soon as you make a dollar, as soon as you do anything commercial, it cross the line. And so basically, domain investors, what you need to do is, if you have a true premium name, this is something I'm sure some friends that we know who have some great names. You've had a name for 20 years. Well, you better make sure it's going to a lander that has nothing, no PPC links, because these things are only getting people in trouble. And you see, that's why they lost alo.com. And John had a room earlier, and he was talking about they got funded recently, or maybe Alo got funded in the last few years, big money. Well, of course, they want the name. They catch you slipping, they had to pay for it, meaning they probably got out of this federal lawsuit pretty cheap, since no one replied, and the fucking case that was made was pretty flimsy in my opinion. I mean, they just had all these PPC links and sort of a cookie cutter type complaint, but it was successful, and that's all that matters. They wanted to get alo.com. They went down the UDRP route. Unfortunately, a panelist said, no, 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 this isn't the place for this. And they, basically took a step back, contacted some smarter lawyers, and the smarter lawyers said, hey, if they're infringing, we can still go after them. And, hopefully they don't answer. And they didn't answer. And now Alo, big company, it was very important for them to, get alo.com. It's a bitch for domain investors, but this one slipped up by obviously, the not answering. I saw a comment on Twitter. I think it was Shane Coulter that said, must have not, or no, it was on DNW. So we always look at DNW, what Andrew's comments are. So be sure to go there, dnw.com. Sometimes we link directly to cases, but many times he'll have analysis of his own on these cases. But anyway, he brought up this case. Shane responded in the comments, well, the guy must have not wanted his name too bad if he didn't answer. Well, we know that's not the case. So before we move on to Pru, and David, I want to ask you, and you can sort of recap what happened in Pru and why it's sort of relevant here. But what are instances? What are examples of instances when a defendant doesn't respond? What are some of the reasons? international, I wanted to say thanks, David. And we're going to talk to John in just a second, but I want to ask Jeff quickly. Jeff, international is one thing. So I want to ask you, what are primary reasons why someone internationally may not respond, but what primarily is a reason that you find when a domestic, it's a lawsuit between two U.S. residents and the person doesn't respond? What do you find are the reasons? But more in court cases like this one. Yeah, there's no real proof of service in the UDRP. Okay, John was really upset with the Alo.com case because he says it could open the floodgates for companies doing exactly this. You aren't successful in UDRP, go to court, and as he mentioned, and John will tell you, but filing this in the Fourth Circuit, which was different than the Ninth, they're basically saying re-registrations can be used as the acquisition date for a domain, and many times re-registration, well, that happens annually. So he brought up some good points earlier. John, what did you want to chime in and say about this? Thanks. I do it real fast like a fucking Indy car. You come in the pits, boom, boom. Go ahead. Well, John, yeah, John, I agree. Jeff, I know you want to comment, and I'm going to let you because I want to hear from the lawyers about the non-service. How do we know, and what are the requirements in an NREM case? But first of all, about the UDRP not being mentioned. Okay, so that can be a big thing. But if the judge is as smart as me, the judge is going to say, "All right, we just said the UDRP hinges on whether there's bad faith registration. There obviously wasn't. The registration was way before the trademark, so the panelist was right. He threw it out." Okay, but that doesn't mean anything in a trademark infringement case. So you guys can bring it and say, "Hey, look, we actually did." That means nothing. And the judge, if the judge was smart, I mean, unless he's pissed that maybe like you guys sent a C and D letter and you didn't let me know, or there was communication between you two. The court wants to know all communicate anything that's related to this case. So I agree in that sense that why wasn't this brought up? But if it was brought up, if the judge was smart, the judge would have said, okay, well, what's that? That doesn't matter. I mean, I remember, uh, yeah, okay. But I would say, John, I think the new lawyer's not acting in bad faith. The new lawyer's thinking, I can't help it that that old lawyer fucking went to the wrong forum. This was never a UDRP case. There's no bad faith registration. This is a trademark infringement case, and that's the facts to it. Well, let's hear what Jeff has to say, and then what David has to say. Go ahead.
name cannot make a motion for a 60B. That is a person that makes a motion.
Yeah, we went through all this in the PRU case, and the guy wanted to volunteer and get in. He could. The Fourth Circuit said, no, you can't. But in the TRX case, the lawyer there was playing some games, and that cost him his reputation. I think he had to pay sanctions for that. He filed made numerous filings in the Eastern District of Virginia, and then and didn't disclose that to the Arizona court. And so there was, I think, an order for sanctions against that attorney. We can talk about it next week, but there was a lot of stuff going on in that TRX case where,
Okay,
yeah, you
certainly
should
the
disclose it.
failure to disclose another legal case on the subject matter is a violation of the rules of civil procedure. It is sanctionable, but not the rules about a UDRP, which is a private dispute mechanism.
Yeah. Well, okay. Well, we'll see if anybody can figure out something, because sometimes, creativity and digging finds more things, more
So,
holes in their case.
so David, in regards to this PPC, because a lot of this suit hinged on that, right? What I'm trying to understand is, why is there so much confusion and different rulings on this PPC issue? Because to me reading the case, I don't feel like this PPC issue was that absolute, because I know that with courts, there's always ways that lawyers from different sides can make different arguments. And unfortunately, we don't know if this person was properly served. I know Michael or Jeff says he was. I don't know that for sure. But I would just say that with this PPC issue, you could say that somebody was airing ads on their domain, but that they didn't know about it. And some courts might say, well, did the trademark holder notify the respondent or the defendant in this case that, hey, this registrar is putting ads up there. Maybe you haven't checked your site in a couple months, but we'd like you to take it down. What I'm asking is, does a trademark holder have some responsibility to at least reach out to someone that they think is violating the trademark, and give them a warning and say, hey, you're violating our trademark. I don't know if you're doing this maliciously or purposely, but we'd like you to take it down? Or is the court's absolute position that if a trademark ad ever appears, then you have the right to lose your property? I don't find that convincing.
Well, we can certainly talk with Jason Schaefer about, get more information. Basically, like you said, John, certainly ask the lawyer that successfully defended the domain owner in the UDRP to say, is there some things that that may help them, reclaim their domain name? Is there a way to do that? But okay, so
Yeah, I was just going to quickly
yeah.
say that with infringement actions, no, there's not a requirement to give someone a warning. Either you're infringing or not. However, most trademark attorneys do give a warning because that helps your case for additional damages for the willful, right? Because that shows that you were put on notice and ignored the notice you were given by the trademark owner, which allows treble damages in certain cases, and attorney's fees. So most in trademark matters, most cases, if they're seeking damages, which most of them are, will give notice. If all you're seeking, however, is equitable relief, meaning forcing the company to stop infringing, then no, you don't have to provide any notice.
Is it possible that the attorneys who were very smart in how they handled this intentionally placed ads on the PPC link to show that, there it is? They waited until their ad propagated to the alo.com. And then when they got that, that's when they started the lawsuit. Could that have been an intentional move?
Pretty tough to do that intentionally, because it's under the control. In this case, I don't know if it was Dan.com or who the company was that put these ads up, but I don't know how it would be possible for someone to kind of monitor the site 24/7 just to wait for a potentially infringing uh, ad. But so it's highly unlikely, not impossible, but I don't think most attorneys are that sophisticated in how to do that.
I don't think they had to
And
wait. I
and
mean,
also,
go ahead, Brad. I was say they didn't have to wait.
no, that's fine. No,
There
that,
was they saw the
but
ads and they said, yeah, there's a case. So right, without if there were no PPC links, there would have been no case. Okay, if this domain owner,
right,
there
that
wouldn't have been a
becomes
trademark infringement case at all. If this domain owner had some silly lander that even just said, I mean, basically, if he had a for sale lander and then this type of case was filed, it sure I don't see how it could have been successful. But and then we would have been talking about, geez, why were these lawyers so aggressive in taking on this case? So I think Wiley Ryan, I think David Westlow over there, who is a very smart lawyer, handles cases on both sides, saw, hey, they're actually infringing by commercially gaining from your trademark, and we're going to go after it. And he might have had an inkling that there wasn't going to be a response to it because of the domain owner's efforts to make their identity, keep it hidden. And but I don't know. Since they did respond, since they did hire a lawyer. Listen, we got to get onto so much stuff
oh no,
today.
just one more thing,
Yeah.
Todd. And Jeff, you had mentioned this, and I want to commend John for being an advocate for all of us domain owners. But are you saying that you don't have to have a signed receipt, proof of receipt that you received information about this ongoing litigation? Is that correct? I know that you used to have, I've been in lawsuits, you need a signed receipt from the post office that, a principal in the lawsuit received information regarding the action. And now you're saying that's no longer necessary?
So it is necessary in any case where what's called in personam jurisdiction is sought. So yes, if I were to sue you individually for whatever reason, you would have to be officially served, and I would have to file a certificate with the court saying you were served. However, in cases, this is a law that was passed in 1999 that says in cases under the Anti-Cybersquatting Consumer Protection Act only, which also is under the Lanham Act. So it's for trademark infringement actions. If you have the ability to sue the domain name itself, if you can show the court that the registrant is not within the jurisdiction of the court, or you don't know who the registrant actually is. And so there are steps that had to be taken before the attorneys um, could proceed in this to the default, which is that they had to show proof that they sent emails to the email address, the official email address on file, um, and that um, and that the registrant was outside the jurisdiction of the court. And then all they could do was sue the domain name itself, which again, all they're entitled to is a transfer of the name and not any damages. So it doesn't change anything about other types of lawsuits. And by the way, this is the same with any property, right? If you own property in Colorado, and you don't live in Colorado, uh, in theory, a Colorado court may not have jurisdiction over you as a person, but it would have jurisdiction over the property there. And so, regardless of whether you consent to being served or you consent to the personal jurisdiction of Colorado, the property is. It's
I
unique
understand.
situations.
That's a very nuanced and very valuable thing to know, right? Because the property itself is intellectual property, but without any personage There's no paternity connection at all, correct? Like with a
And so
work
the
of art.
only,
I'm sorry.
so yeah, so then, right, that's correct. And so therefore, the location where you can, where the property is located has been deemed by law to be where the registrar is or the registry is for that particular top level domain.
Thank you.
Yeah. Yeah. In
So
this
just to
case.
clarify things, I'm on archive.org. The case was filed in June 2024. In the first 6 months of 2024, there is no PPC ads. There's something written in Korean, then something in English saying this name is not for sale, and then the name in big bold letters, domain ka, like domain CA. And yeah, so the last ads that appeared were in 2023, and those were Google parking ads using the standard PPC landers that were probably there when the UDRP was filed in 2017. So yeah, if there was no ads in 2024, then how, like, why didn't they disclose that to the court? Like, that is something I think that there's like no infringement happening in 2024.
Yeah. Well, I don't know. They need to disclose that. There was infringement. You don't need to say when it stopped. But John, I want to say to John, I'm with you. I wish I'm part of Internet Commerce Association. Well, it's not their job. I sure would like it to be to say, hey, in this case, there's a domain name here that's worth hundreds of thousands, if not $1 million. So what we want to do, at least, and Jason's a member of the ICA too, at least we want to reach out, somehow contact this domain owner, because no one wants to lose a $500,000 property, $1 million property. So what we want to do is slow things down, give him a chance to respond. David has brought up a lot of good reasons. There's a lot of things that even and John, you made the good point. A lawyer slows things down for the defendant and says, here's the UDRP, even if the judge says, I don't care. So what? Terry Livian said that to Jeff. So what? Okay, so even if he brings up things, he's going to bring up all sorts of things like David just mentioned. Here was the landing page, the most recent 12 months. Here is why there were parked pages, and explain the Google. So if a defendant lawyer could slow things down, there surely is a defense here, and a defense to hold on to your own property. So there is a case, and you need to, that's why the defendant needed to make a case. But then Jeff says, okay, it's like having the property's here in Colorado in a garage. It's a car. We can't find the owner. We've tried to find the owner. We've looked, of course, the DMV records and so on. We can't find the owner. So we're going to sue for the property and what jurisdiction that property's in. And then we are limited, though. We can only get that property. So, there's reasons why, I've learned myself why they have these in rem cases, the limitations to them. But this domain owner has done himself no good by this friggin' privacy, and then not being available, not answering. And if he can answer a UDRP and they sent to the same email address, then why is he not, responding to this? So there's, we'll try to, if we get more information, we'll talk about it. We're going to talk about maybe Prue next week. That's an old case anyway. That's prudential. But if you look at our outline, dnlshow.com, we had a bunch of bullshit we were going to talk about today. And then we're just going to go through it so we can get to our cases pretty fast. If you do have a legal question for the lawyers, we still may have some time. I doubt it. But anyway, raise your hand. Come up here. We'll make time. But if you look at the outline, dnlshow.com/outline, on B3, there was a quick article Domain Gang put up about ownthelibs.com. A Chinese registrant uses DeepSeek to their UDRP defense. I thought it was interesting because this Chinese registrant, he bought the name libbs.com, libs, and that's where Domain Gang came up with the funny title. But he bought this name, and he said, my last name's Lee, Li, and I was going to set up a bulletin board like back in the day, BBS. I was going to set up a bulletin board for my family. That's what the Chinese registrant said. Well, DeepSeek, I'm sorry, and he used DeepSeek AI to respond to this UDRP complaint. Well, the plaintiff in this case, Libs, some company named LIBBS said, no, this person has no right to it, no legitimate right. This is a unique, trademark, and this person got it on the drop uh, because they wanted to, basically keep us from having it, and they knew our trademark, and they, would like to sell it to us. The Chinese registrant once again said, using AI as a defense, no, I bought this because it's my last name, and I was going to set up a bulletin board. The interesting thing about the decision was the panelists said, people haven't used bulletin boards since 2012 in China, or some bullshit like that, which really did. But anyway, the person lost the domain name, LIBBS. So anytime we see a domain name lost in a UDRP, of course, domain investors, we side with the domain owner. Why? So I think this was, we're not going to review this entire decision, but I think this was a a bad decision, but the Chinese registrant decided to use AI to help them answer. I think it's going to be frequently used in the future to answer UDRPs and help lawyers in, real complaints. But any comments, David, Jeff, on this one?
Well, first of all, use the wrong AI. Using DeepSeek is probably not, and the way he uses it is wrong. So you're supposed to have a pre-trained AI that knows all the cases and figure out the basis for your response. Then you can use DeepSeek to dig for more evidence of good faith or whatever. So that's my comment on that.
Anything, Jeff? Anything worthwhile there? We'll move on.
I mean, it all comes down to the credibility of the registrant too, and the panelists just didn't think that this was a credible, just credible excuse, and using if you're relying on AI to write your defense, and uh, you can get help with writing it, sure, but you can't just make up facts that just seem it just doesn't seem right. It's not credible.
Well, this next article, the next couple articles I picked up from DNW.com. I want you to check them out. I mean, it's Andrew Alleman's website. He's been doing it for 20 years. I think it's been 20 now. Can't remember. It doesn't matter if it's been 14. It's been 20. DNW.com, he doesn't veer away from a lot of the legal issues and comments. Basically, he's a place where you can find a lot of legal cases if you don't have access like the attorneys do. I bring it up because some blogs, avoid a lot of the legal stuff. Andrew certainly doesn't. And this next article I saw that he wrote about was this was the one where this expert witness, he's an engineer, but he's an expert witness in domain cases, some kind of bullshit. I don't know. He's an expert witness, so he decided to go after EW.UK as in expert witness. So he files a UDRP for EW.UK, and the domain investor is a company, AnyWeb Limited, that owns 50,000 domain names, and they own a ton of them of two-letter .co, .uk, and .uk. So this person filed this UDRP because he was trying to make a case that he's an expert witness. This is short for expert witness, and he's got some UK trademark for EW, and I guess he's on EW legal. So he just felt like, I don't know, he tried to get the valuable name, but one of the smartest panelists that we know, Tony Willoughby, he's over there in the UK. He said that, no, this was a Plan B reverse domain name hijacking case. The complainant in this case really, reached out, wanted to get the name. I don't know the negotiation that went on, but he didn't get it. So it was too expensive. So then he went and filed this case, and then he tried to withdraw the case, is why I bring it up. And I wanted comments from you, Jeff and David. So this guy filed the case. He tried to withdraw the case before it was decided because he's got an inkling that, he wasn't going to win. But Mr. Willoughby went ahead and rendered the decision. He didn't let somebody back out of the case. He wanted to really, make a statement of saying, you do this and we're going to, explain the ruling and rule RDNH against you. Any comments you have on this case, Jeff?
Well, I mean, on the last point, it's up to a panelist whether to dismiss it or not, or to allow the withdrawal. I don't know in this case if the respondent said, no, I don't want it. I want a decision on the merits. But sometimes respondents will say that. And in fact, oftentimes, if they're represented by counsel, respondents will say, no, you had a weak case, and I want this decision to be issued in my favor because I want a record of it. And so, I think certainly if there was a if it was a default by the respondent, like there was no response filed, and I were the panelist, generally I would allow the withdrawal. But if there was a response filed by the respondent, then I would only allow the withdrawal if the respondent um, consented to it. Because obviously they took the time to respond. And if they did, then I would leave it up to them as to whether they want to agree to the withdrawal.
Yeah, if the person responds or has notice and is planning on responding, then yes, he should be able to object to a withdrawal.
Yeah, we're going to get to our case reviews today. Everybody, thanks for joining us. Next week, you got to be here. We have a domain investor who's probably more suited for the type of room I'm having tomorrow with Josh Reason, tomorrow morning at 10 a.m. Pacific, 1 p.m. Eastern. Here on Space, Josh and I are going to be talking about domain investing. Next week on the Domain Name Law Show, we have Sten Lillestrom, who I believe is one of the best domain investors of all time. And I mean, he really came in like a tornado in domain investing this last decade, has 10,000 plus names, and he invests in brandable names. And those are, I don't know, I can't say notorious, the hardest to sell. He's been so successful, top seller over at Adam for several years. And he's going to talk really about why these fanciful names, these brandable names, are in fact more valuable and sometimes difficult, sometimes less difficult to defend in a UDRP. We're going to talk about legal issues with them, but also basically just the value and how to value brandable names and why some sell for a lot and some don't. But that's next Tuesday here, noon Pacific, 3 p.m. Eastern. Okay, but so today, before we get to our cases, there were one other really news article, and that was there's a registry that owns a lot of, like these .law names, okay, and the registry is who's the registry here? Registry Services. Okay, so it's GoDaddy has this Registry Services division that handles their GTLDs. They're, I guess, these strings that they manage. This X law group filed a lawsuit, not a UDRP. They filed a lawsuit in California against X.law and its owner, which is Registry Services, which is GoDaddy, a subsidiary. So the reason why I bring this up is because they're saying this could be, I guess, it could set a precedent on how registries are going to deal with, lawsuits against some of their premium names. So what I thought was interesting is X.law was picked up by the Registry Services because they're saying, and Jeff, you can answer this for me. So sometimes the registry doesn't want to leave it as a premium name, so they actually purchase it from themselves. Is that standard practice? What do you know about that?
Well, registries do it differently. Some do register it so that they could put it, you have to register the name if you want to put something in the zone. Meaning, if you want a web page to appear, you have to quote, register the name. And whether you use a registrar to do it, whether you do it in your own name, do it in someone else's name, that's completely, up to you. And with truly generic TLDs, it's usually not a problem. Um, but with specialized TLDs or ones that have requirements like .law in this case, not a good idea if you yourself don't meet the requirements to have a name to register it in your own name. So because Registry Services, formerly Newstar, is not a legal entity that would otherwise be entitled to have the name, they should not be registering domains in their own name. Um, it's just not a good idea. Yes, perhaps people will then see if you registered that it's for sale, but if you're ignoring your own requirements, that doesn't look good. So if but like for hip hop where there's no requirements, for example, that you be a hip hop entity or whatever, if I wanted to register it in my own name, because I want to put content up or draw people to it and let them know it's for sale, then yeah, as a registry, I am the registrant and I am responsible for any infringement or anything that happens. So I don't know if it'll change the way that registries do premium names. I just think it'll change registries that don't use my expression, but I think it'll. Wait, I won't say that. I won't be mean. I think registries will be and should be more cognizant of issues that might come up if they themselves are the registrar. It's, I think, a better political way of saying it.
Yeah, in this case, so right, they're the ones that made the restriction that it must be a law firm, some legal entity like that. And then, so I could see them having an excuse around it, saying we're the one that made this restriction for the names, but we can make an exception for ourselves because of the nature of our business and what we're doing. So I think the bigger issue is if you do hold back premium names as a registry and there's a UDRP against one of your premium names, well, I don't know what the big deal
Well,
is. Basically, you got to
I
defend
just
it
want to
like
make,
anybody else.
yeah. Well,
Go
I
ahead.
want to make, a distinction. You can hold back premium names without registering them. The only reason you register the premium name is so that you could put it in the zone and have a live website. So hip hop has a ton of premium names. We haven't registered them, so they're not in the zone. So you can't go to a website and see that a particular name is for sale. But registrars all know that it's premium because we have a list that registrars check up against, and they'll know it's premium. So I want to separate out the issues here. It's not the fact that they decided a name was premium. It's the fact that they decided to put the name in the zone by registering it and have something appear on that website.
Understood. And
Y-
my defense, if I
Yeah.
was on behalf of the registry, I'd say, right. And that's exactly why we did register it for the dynamics of, I mean, it has to happen for it to resolve. And we're not, registering it, even though you consider us a registrant. But no, I get you, Jeff. Good point. And I think that they're going to say, here's the reasons why we have to do this formal registration when in fact we're still going to offer it just like we do our other premium names, but we wanted to be able to market, and yeah, I think since they're the ones that also make that case that make the restriction. Well, let's quickly get to our cases. The only if anybody checking out our outline, you can see all these links on here, links to these stories that we talked about, and the links coming up to our cases. The final link before our cases was WIPO and ICA release UDRP report for public consultation. It's interesting. Basically, if you want to check it out, go to the link, and that's the ICA link, and then it'll show you the actual report. But Zach Muskovich and Brian Beckham of WIPO, plus 16 UDRP experts, and then up like 28 subject matter experts. Basically, a lot of the people we know, Jason Schaefer, for example, Paul Keating, Nat Cohen, and so on, Gerald Levine, John Berryhill. So many contributed to this, and it's really basically a document that's been put together for ICANN, and really a lot of different entities and experts have worked together to present this to ICANN. So this public consultation is what I guess they're looking for feedback. But anyway, the links there. We got so much to do. Paychecksformoms.com is our first case. Thanks for sticking around. Paychecks, Paychex, formoms.com is our first case. A lot of you may have heard of Paychex. Okay, Paychex. They're the complainant in this case. Okay, in the old days, this, in my opinion, would have been sort of some type of fanciful name. That's not how you spell Paychex. It's a unique way. This company goes by Paychex, and it is unique. Now, with the way naming has gone in the last decade, 2 years, 20 years actually, and this is what we'll talk with Sten about next year, is Paychex is really Paychex is an alternative way to spell paychecks. So it's almost generic rather than so unique. It's an alternative way, to spell paychecks, CKS, because phonetically it sounds the same. But anyway, in this case, Paychex out of New York, big company, filed this UDRP against little Carolyn DeBerry out of Tennessee. Well, the complainant is on paychex.com. Okay, they also own paychek.com since 1991. But interesting. So they've been around for a long time, and they said, what's interesting about this, they don't like anybody to use Paychex with an X. Okay, so they go after many different domain names. They're successful in, most all of them from what I was looking at. But in this case, this respondent had a website called the Income Club Membership. It's almost like a multi-level marketing, like a pyramid type thing. How do you like that, Siger? A pyramid, and where you join and then you get paychecks back. I don't know. You join for 10,000 and you get $1,000 check per month for how long. I have no idea how it works, but it sounded like a pyramid scheme to me. But that's what's on the disputed domain name. Like I said, the complainant doesn't like anyone using Paychex, but they felt like this person uses our mark. It's in the domain name, paychecksformoms.com. The domain was just registered here in 2024, a year ago, last May, and they did their standard complaint, and the respondent did not reply formally, but did send in an email saying, listen, here's exactly what I do. Please, here's my phone number. Call me if you need to. But what was interesting is Alan Limberry's decision, because in this case, I would think, I was expecting a domain transfer, a transfer decision. In this case, the domain owner got to keep her domain name. It was a complaint denied. So first, I don't know which one of you want to jump in and talk about paychecksformoms.com and this decision that Alan made.
I can start. So it's interesting that, she does have a live website. She is offering some sort of pyramid scheme or down. You just have to become a member and you recruit other members, and there's some marketing involved, but it's not clear. And somehow you get money in the bank every time you have a kid or something. I don't know. So that's what it seems like. So she's registered a business. It was first incorporated, then that dissolved, then she registered an LLC. But in the meantime, she applied for a trademark in her name, doing business as Paychecks for Moms LLC, which is the weird way of doing it, but she named herself individually. That application was filed in February 2022. It still has not been examined 3+ years later. So that's odd. But then she did register her entity as Paychecks for Moms LLC. And the panelist said, yeah, she's commonly known as Paychecks for Moms because she has her company name for that. And that's what I'm going to accept. Now, there are 3 UDRP complaints made by this Paychex complainant. Two are transfers, and this one was not. But there's over 400 domain names, including the word Paychex on it, including AIPaychex.com. There are so many of them. I don't think that they plan on filing UDRPs against all of them. What do you think, Jeff?
Yeah, I mean, I didn't know about the other two that were filed, but certainly in this case, um, while not filing a formal response, filed a email response. And like you said, David, they found that there were rights or legitimate interests in the name well before this dispute happened, and therefore, you don't go on to the bad faith argument, and that was the right decision. If the complainant still has an issue with the way it's being used, it's free to go to court and allege infringement. But um, you know, having legitimate rights, uh, I should say, in a UDRP, just because a UDRP finds you have legitimate rights doesn't mean you're not infringing. And so at least at this point, the name is safe with the respondent, and we'll see if the complainant decides to go to court over this one.
Yeah, this was an on the fence decision, in my opinion. I mean, I would have thought because of their success and the well known, the popularity of their mark, but Alan's down in Australia, so he might have not known the the popularity and the well knownness. I can't think of any word for this particular mark, because when I see PAYCHEX, I think of that company, Paycheck Systems or whatever they do. I don't even really haven't looked at it, but he immediately just said it looks like there was something legitimate. So, like you guys said, of course, we don't have to rule on whether it was registered in bad faith, because it was registered well past, you know, 30 years past the trademark. So that was a complaint denied, and really unusual. We all like to see when a big company doesn't you know doesn't easily get their domain name. I think if they would have, I don't know what they could have done as the complainant to win that case, but it was really unusual because he was somebody running a pyramid scheme. It sort of really puts your mark in a bad place when someone's running some kind of scheme like that, and then the panelist doesn't side with you. But he's smart. Alan's like, we got to leave that for the course. This next case, so that was a complaint denied. The domain was paychecks with an X for moms.com. Complaint denied. We win one. Okay, Dream Studio is this next domain name. Dreamstudio.com. Really great domain name. It was registered April 29th, 2002, which comes into play here. The complainant in this case, Stability AI, filed this lawsuit against Lauren Haynes. Dream Studio. So this was an interesting case in that the complainant was, founded in 2019. It's an open source generative AI company. Okay, so it was just formed in the last decade. Stability.ai is the main domain that they're on, and the website, and they also own dreamstudio.ai, but this complaint is about the name dreamstudio.com. Well, this respondent had registered it a long time ago and really had the name for for this entire time. Now, because they eventually did change the content on this page, because originally this person registered it because their name was Dreammaker Studio back in 1997. They found, they created an S corp around it in 97, Dreammaker Studio, and then later in 2016 they changed the name to Dream Studio because they had changed their S corp to an LLC. So they changed to Dream Studio. So that tells us there really was, some legitimate business there this whole time. What was really unusual was recently on the website, the domain owner actually put links right to stability.ai, right to their product, their Dream Studio product. And when the complainant, reached out to him, sent him I believe sent him a CND letter, on January 25th, 2025, earlier this year, sent him a letter just saying, hey, listen, you got to remove all these links. and you need to transfer the domain to us. Well, the domain owner said, I'm removing the links. Of course, he didn't transfer the name, and said, but here's one thing I will do is if you hire me, you know, over at your company, and I'll sell you the name for a reasonable amount. Had it originally listed for 750,000, which dreamstudio.com, pretty cool name. But basically, the guy said, "You hire me, I'll sell you the name for 200K, and if you give me a job, making 200K, we got something happening here." Well, the complainant, one thing, he did offer 20K for this domain name, but was not going to come up to that price. So the complainant filed this case and said, and I'm about done here, to say, listen, this respondent has 25 other names he has for sale for big amounts, to up to 250K. A lot of them include trademarks. So they felt filing this case was worthwhile. There was a three-member panel. They felt like it was worthwhile because this person started infringing, they felt, on their mark. And they said the re-registration of the domain name and the change content allows for them to file this case, and felt like they could win this case. Okay, so I've said about everything. There's probably nothing left for you guys to talk about. But David, go ahead, and then Jeff, make some comments. And
Yeah, this is one of those situations where it's good that there was a response, because the complaint here basically lied, misrepresented the facts. This website has resources on there to a whole bunch of AI generated stuff. For example, Google Firebase Studio, flora fauna storyboards, Midjourney images, Pika images, Luma, Dream Machine, Dream Booth characters, 11 Labs. It has all these things on here. And this guy has been running a meetup for years, and it's called Dream Studios. You can schedule, there's a meetup every Thursday night at 7 p.m. in both New York and Atlanta. You can attend online. And his actual members have been populating information on the website. Now, if you take a look at the complainant's GitHub page, every GitHub page has its own README file with its own copyright license. And Stability AI's copyright license specifically requires, it's a CC 4.0. It's more strict than the traditional Apache license. So you have to give credit to Stability AIs. You have to mention them. You have to provide a link to the license. You have to indicate if any changes were made. So they actually don't want you to change things. And if you do, you have to say what you changed. So this idea that there was copying going on maliciously is a false suggestion. That's what their own terms of service say on GitHub. So yeah, this case was totally fraudulent. What do you think, Jeff?
Yeah, I mean, I loved the whole decision up until like the last paragraph. And I think it's because the chair, Doug Eisenberg, is so much of a trademark attorney. So I think in the last sentence it says something, obviously finds in favor of the um, respondent, the registrant. But then they add at the very end a statement that says, to be clear, the panel expresses no opinion as to whether respondent's use in bold and underlined of the domain name may be in bad faith, including causing a likelihood of confusion with the Dream Studio trademark, or whether an action by a complainant in a court of law would be appropriate, only that the policy requires registration in bad faith, which does not exist here. So, first of all, I think that was probably its statement as to why it didn't find reverse domain name hijacking, which I think should have been found here because of all the reasons, David, you mentioned. So up until that point, I think it was a great decision, and it codifies again the notion that retroactive bad faith is a disfavored or discredited legal theory that nobody follows anymore. Namely, that a renewal can be a new instance of a registration in bad faith. So everything up until that point, to that very last sentence, um, I was very happy with the decision. Uh, but if I were the panelist, I reading this case and for the some of the the reasons that David said, I would have liked to have seen RDNH here.
Interesting that you say that. And this case, dreamstudio.com, would be similar to the Alo case, meaning the panelist was saying, hey, they certainly didn't register the name in bad faith. We can't find that, so we're going to deny the complaint here as a UDRP complaint. But if you went to court, maybe there's something there. And um, as you mentioned, Doug
Right,
Eisenberg.
but I don't like that um in this type of case, because you're almost telegraphing that we don't like what the registrant's doing, and therefore we're sort of recommending you go to court. It just, to me, that kind of line um is not, the way it's phrased here is not, I think, the appropriate way to handle.
Right, they could just say we make this decision without prejudice or whatever, right, Jeff? Just let them
Yeah,
know.
or it could have put it in the reverse domain name hijacking section, which says, look, we're not going to find, which I disagree with this, but they could have said, we're not going to find RDNH here because we think that they're um, there potentially may be some claims if this were filed in court. So we're not going to find an abuse of the process. Again, I wouldn't have done that. I would have still found RDNH. But if it had been in that section, that would be one thing. But to not even address RDNH and to put the sentence in there, it, it shows sort of the biases of certain panelists.
Well, sure. And then when someone asks for a job from the complainant, the panelists, they don't like that, especially a brand lawyer thinking, yeah, see, that's a form of targeting. They targeted him for a job. They asked him for a job. And Doug was, the gentleman who last week, that GDOT case, he said he's from Georgia and he thought, unfortunately, it's too bad Georgia Department of Transportation didn't win that 4 letter. And then, Sten, who's going to be here next week, the domain investor, he's the one that brought my attention. He's the one that put on LinkedIn. Unfortunately, why? Why you say unfortunately? Because these little things, like you mentioned, this little comment at the end, why do you're not really putting your tip in the scales here because the decision was made, but you're just adding something to show your bias towards the brand owner. A tiny bit, and especially like when he said, "Unfortunately, GDOT. It's too bad they didn't get that." Why would you? Why would you want somebody to get property they don't deserve? But brand attorneys, I was going to say maybe not that, but they can't help themselves. They see it, and they still. I know when we're on some calls, Jeff, speaking with lawyers and stuff, the ones that are the brand lawyers that have it in their blood, they they don't want to say it, but domain investors, they prefer to see when a domain investor, when it's on the fence, lose the name. When we know if it's not, a clear cut, we're thinking you should be able to keep your name, first come, first serve in domain name registration and investing. And unless it's, flagrant in your, cyber squatting, it shouldn't be taken away. But anyway, the brand lawyers just think, you guys, we get paid by these brands, and we want to fight for them, even when it's a losing cause. Okay, this last case, and we're going to get out of here. BELIAHOME.com, BeliaHome.com. Got to tell you, I don't even know why I brought this case up and added it to our outline, but it was a case where the complainant, it's an international company in Barcelona. They own the trademark since 2012 to Belia Home. They're on BeliaTrading.com, and I can't even think of what business they're in now. They were in like every business. David, do you remember this? What business they were in? It's like something about trademarks even. And anyway, I mean, do you recall what business this company was in?
The complainant's business, it doesn't actually say in the complaint. They just say they have the registrations.
I thought it
Spanish
did.
one and
The Well, the interesting part about this case, so we'll get right to it. So all three cases today were complaint denied. The domain owner and the complainant in this case, Jaffer Entertainment, or Jafer, Jafer. Was it Jafer or Japer? I can't tell my writing. And I'm not looking at the case, I'm looking at my writing. Probably Japer. But anyway, they filed this against Tony Arend, a woman that owned the domain name. The interesting part about this case is the panelist, John Swinson, single member panelist, said although the domain was not registered in bad faith, so use doesn't matter here. And we ran into this before. The panelist brings up this 3.9 WIPO overview. In the overview 3.0 says that renewals is insufficient for bad faith ruling. So anyway, once again, panelists it seems like there is an agreement in the UDRP that renewal alone is never sufficient for a bad faith ruling. Now, acquisition date is different. So is that how you see it, Jeff? Always a renewal means nothing, but you can use an acquisition date if a complainant says, here, we can prove this was acquired after our trademark, forget the original registration.
Yeah, I mean that's right. That at least with UDRPs, it's not a renewal that's important, but it's if it changes hands. I mean, if it changes hands in conjunction with the renewal, then of course that date's relevant. But yeah, I think that is right, at least under the UDRP. And as we've discussed many times, and even in the Pru case, I think this was an issue. The lawsuit, sorry. Uh, there's a split among circuits as to whether a renewal is considered a re-registration or not under the ACPA. So yeah, I mean, I think that's right, and I think this case came out correct. I think the respondent's story is very plausible, and I think shows that there's a legitimate there's a legitimate interest, or at least no bad faith, um, or nor any way that the respondent really could have known about the complainant, nor was there any kind of evidence submitted that would show that. So, I mean, all in all, it was a good decision.
Yeah, and also Belia is a girl's name, meaning beautiful. So, it's not implausible. They talk about nuclear marshmallows in this case. It's like not implausible she would register it. She had no way of knowing about these foreign registrations. Interestingly, I Googled Belia Home, and the first website that shows up is BeliaHomeEcuador.com. And I guess they're based out of Ecuador, but that's not where they have the registrations, or maybe that's a different entity.
Yeah, and David, thanks for bringing that, because I forgot to mention. I think it's one of the few cases that accurately cites the Telstra case, whether the passive holding of a domain name can be bad faith. And this case points out what's true, which is that Telstra was decided because the mark that was in question was famous and well known where the respondent, the registrant, was located. And that is an essential element. It's not passive holding can automatically be considered bad faith. It's that passive holding of a well-known or famous mark can be bad faith. And so I appreciated that reference, and that's one to kind of bookmark if someone ever makes a claim that your passive holding of a domain amounts to bad faith.
Thanks for that, guys. I was going to mention, David, so the complainant is an international company based in Barcelona. Listen to this. You've never heard of a company that does this. They specialize in the design, creation, registration, and exploitation of trademarks, formulas, fragrances, cosmetic products, and the research and development of technologies. I mean, what category is that? I mean, that covers all sorts of crap. But the point was, they registered their trademark in 2012 over in Spain, Then they had some Colombian trademarks in 2013. They didn't have their Mexican trademark until 2024. But the respondent here we want to mention did respond and said, listen, I don't know this company from Adam. I'm here in the U.S. Never heard of them. The reason I registered Belia Home is because, like David said, it means beautiful. Could mean beautiful home. Because, but the respondent said because Bella Home, which people know is the term for beautiful, um, was taken. So they said Bella Home was taken. So I'm registering Belia Home, and of course there was no bad faith registration. I didn't even know of this. And fortunately, just them responding and saying that under penalty of perjury, but saying that to the panelist really meant a lot. And anyway, so the respondent states that it did not list the disputed
I
date.
want to add something here.
Yeah, go ahead.
So this Jaffa Enterprises, they have 3,200 trademarks. Most of them are in Spain for a variety of terms that are either one word, like even temptation, bioeffective, SER, O de Seda. These people are trademark squatters, and they're trying to scoop up domain names. I remember this was a big issue back a few years ago where there's other people doing the exact same thing out of Denmark. This is a bad actor. He's actually trying to steal domain names.
Yeah, registered the trademark for just the term BELIA too, under all those different categories. Crazy. Okay, so that was a complaint denied. So in our cases today, paychecksformoms.com, dreamstudio.com, and beliahome.com, we have good news. The domain owner got to keep each one of them. It was the big case, alo.com, the more expensive name, was lost in the lawsuit. We might talk more about that next week. But anyway, I doubt it because next week we have special guests. So I'm closing up by telling you 2 rooms you got to listen to. Okay. First, tomorrow, Josh Reason and I are doing a space 10 a.m. Pacific, 1 p.m. Eastern, right here. We got some special guests too coming in. We're going to talk about fair market value of domain names, but all sorts of other domain investing topics. And it's an open stage, meaning we're going to let any goofball up. I can see plenty in the audience that are goofy. Come on up, and we're going to talk about domain investing. And really, it's fun to get specifics and really pick Josh's brain because he full time every day, working on his portfolio. And basically, it's a full time job. Love to hear what he has to say and why he believes fair market value for a domain name is what you can get out of it in 24 hours with like 2 people willing to pay for it. But we'll get into that tomorrow. Next Tuesday, right here on the Domain Name Law Show, noon Pacific, 3 p.m. Eastern. Okay, that's next Tuesday. Sten Lillestrom, who, fantastic domain investor. Is he out of Sweden or Netherlands? I think it's Netherlands. But he's going to stay up late and he's going to join us. And believe me, he has tons of valuable info at the ICA meeting. I sat down with him. I could have talked to him just for hours and hours on end and really trying to get tips from him on what is he investing in now. All the success he's had at Adam with these names that seemingly, how do you sell them without help from brandable marketplaces? He has some insight on, here's how you can sell these names without being part of marketplaces. But he and I are preparing a great outline for next week. So please join us here on Domain Name Law Show with our special guest, Sten Lillestrom, next week. That's next Tuesday, the 29th. And then tomorrow morning for me, 10 a.m., 1 p.m. Eastern. Join us here on Spaces, me and Josh, for some domain talk. Everybody, thank you so much for being here. Have a great rest of your evening, morning, wherever you're at. Take care.